ADR, Alternative Dispute Resolution. In case of ADR, nothing but whenever there is a dispute between two persons, in order to solve the dispute, what are the various ways and means available? There are different ways like arbitration, mediation, conciliation, negotiation, and others. Whenever there is a dispute between the two parties, if you want to sort out the issues between the two guys, what are the various things available? There are different methods, and apart from this we have one more: litigation. Litigation means filing the case, examination, cross-examination, re-examination, and so on, right? So whenever there is a dispute to sort out, these are all called, apart from legal, what are the alternative dispute resolution? Filing the case is one way. Anyhow, I can go to court. If I go to court of law, what will happen? It will take its own time. In India, justice is not denied, just delayed. It may take the 1 year, 2 years, 3 years, sometime 20 years also, I don't know. Money involved, time involved. Whereas alternative dispute resolutions are there, like arbitration is there, negotiation is there, mediation is there. Otherwise, I want to settle outside through the Lok Adalat, I can go. Easy way, less expenses, less time, in a quick manner, I can get a justification. So whenever you want to sort out the differences between the two persons, this is alternative procedure. There are two types of the broad methods are available. There are two broad heads. One is adjudicative, other one is the consensus process. Adjudicative means litigation, whereas the consensus process means arbitration, mediation, litigation, nothing but a conciliation officers. So consensus means meeting of mind between the two persons. So finally guys, whenever you want to disputes are there in relation to trade, commerce, industry, treaties and contracts, the best method is always go settlement outside the court. Inside the court take its own time. That's only one requirement. The most common form of the judicial resolutions are nothing but a litigation. In case of litigation, what will happen? I file a case against you. You file a case against me. Then case has to be listed. It may list, may not list. It will take its own time. After listing, first examination, then first appearance, second appearance, third appearance, then first hearing, second hearing, and so on. Finally, final hearing. In between, sometimes advocate may come, may not come. It's a process. Time and cost involved. By that Jayalalitha case, remember, it was taken 20 years to get a judgment. 20 years, late Jayalalitha. After 20 years, judgment has come. And court said, put her back off the bars. She was arrested and put in the Bangalore jail. I don't know how many of you remember. And today also, Jagan Mohan Reddy case, almost 15-20 years. 15 years completed. Expeditious manner, one has to complete the process and take a decision. What is the otherwise the criminals are occupying the highest positions in the state. Then the integrity of the country may be at stake. That's why right person should be at the right place. Things should happen. Litigation, the entire process will be there. And that's why this is formal. This entire paragraph speaks about your litigation part is concerned. If you want to go through once, litigation is initiated by one party, files a suit against another person, and proceedings very formal, nothing but a legal manner, an official manner, governed by the rules, such as the rules of evidence and procedure, and finally established by the legislature. And the outcome decided by the impartial judges, no partiality, based on the facts and figures, evidences only, judgment will be given there. as per applicable laws. The verdict of the court is binding the party. Verdict means judgment. Judgment is binding the party. If both the parties have a right to appeal, in case if you are not satisfied, you can further appeal. Appeal into the Supreme Court, appeal into the upper court. There is a lower high court or a Supreme Court, you can appeal. This entire paragraph speaks about litigation process. Now next one is methods of the resolutions do not involve the litigation. Means no court process involved here, and though they are generally classified under the alternative dispute resolution ADR. Means apart from litigation, is there any other mechanism where the issues between the two persons can be sorted out? For that sake only ADR. The under ADR generally depends upon the agreement by the parties in use to ADR process, either before or after the dispute. Before or after the dispute, what does it mean? We are entering into an agreement for supply of the goods or purchase of the goods, whatever. In agreement only one condition is there. In case of a breach of a contract, aggrieved party can go for arbitration. In agreement only it is there. Otherwise you can go for the mediation, or you can go for the conciliation. In agreement only it is there. So rather going to court of law, I can go for the settlement through arbitration. I hope you are understanding. In agreement before or after. Before means before we sign agreement. In agreement itself it is one of the condition. Or after the contract is breached, both the parties agreed that we can settle the case amicably outside the court, so that we can go for mediation. Can we go for arbitration? He said yes, sort out. You need not always go to court of law, na? Thereby you can sort out in the outside the court also. That's why before or after the dispute arises. And ADR experience steadily increasing the acceptance and the utilization of the because of the perception of the greater flexibility and speedy resolution of the disputes among the perceived advantages. Because court will take its own time and money, whereas it will come in one sitting, two sittings, or three sittings maximum. Problem can be sought out. Speedy manner, expeditious manner. ADR is the term used to describe the several different methods of resolving the legal disputes other than filing a suit and timely justice. The courts are backlogged with the dockets, resulting in the delay of the year or more parties to have their cases heard and decided. To solve this problem of the delay, Justice ADR mechanism has been developed to respond to them. This method can help the parties to resolve the disputes at their own time terms expeditiously. Means speedy manner, quickly, own terms and conditions were defined. And the ADR techniques can be employed in several categories of the disputes, especially civil dispute, commercial dispute, industrial dispute, and a family dispute. Means except criminal nature, crime was not there, all cases can be referred towards the arbitration purpose. If you murder a person, kidnapped a person, or dowry harassment, such a cases cannot be referred for the arbitration. Otherwise nothing but a ADR. Other than that, civil means damages, and commercial means agreement, breach of agreement and all. And industrial means supply of the goods and buying of the goods, any kind of violations. Family means within the family disputes, property matters are there. Most of the case property matters only. As long as the property is not involved, no dispute between the two persons. So ADR takes its fold and various methods for the settlement, including Lok Adalat and arbitration, conciliation, mediation. Now guys, it was suggested by the Law Commission of India. The court may require attendance of any party to suit or proceedings to appear with a view to arriving the amicable settlement of the dispute between the parties, makes an attempt to settle the dispute between the parties amicably. Means rather coming to court, we want to sort out outside, you can sort out. I think I told earlier one example. Vodafone versus the Government of India. Regarding a tax matter, there was the dispute. Supreme Court trial going on. In the meantime, both the parties, Government of India, Vodafone, wanted to settle the case amicably outside the court. The same thing they informed to the Supreme Court. We want to sort out. Then Supreme Court said only one thing. If you want to sort out issues, you can. But file one affidavit that we want to sort out this one through arbitration, mediation. You tell one, file one case, nothing but affidavit to submit. Affidavit means written promise. They have submitted. Court said, go ahead. Case was closed. Means if you want to settle the case outside the court, Supreme Court also will submit. Go ahead. No issue. You need not come every time to the Supreme Court for the sake of a settlement, isn't it? There is no crime involved. So that we need not examine any kind of witness and all. If you people wanted to settle outside the court anything, you are always welcome. Thereby. And Section 89, the Civil Procedure Code lays down settlement of the disputes outside the court through arbitration, conciliation, judicial settlement, that is Lok Adalat, and mediation. So according to section 89, only these are the four methods how the problem can be sorted out. Second one, where a dispute has been referred to. Who will give the reference? Verify carefully. For arbitration, conciliation, the Arbitration Conciliation Act 1996 shall apply, and proceedings of arbitration, conciliations referred for settlement under the provisions of the Act. Do you remember? Arbitration as well as the conciliation. This is purely parties' will and wish. Parties has to decide. This issue will sort out through conciliation. This issue can be sorted out through arbitration. In agreement, parties are agreed. Go ahead. There is no other procedure here. Who give reference here? Parties only. Parties, disputing parties can make a decision on that. Second one is Lok Adalat. For a Lok Adalat, remember, the court will give a reference. We want to sort out the case through Lok Adalat. You file an affidavit and the court give a reference to Lok Adalat. When you go to the Nampalli court also, you can see one specific court hall is there, Lok Adalat. Nothing but a people's court. Lok Adalat is called people's court. Judgment will come in expeditious manner, very fast, and it won't take its own time there. Okay. So it is also referred by them as same to the Lok Adalat according to provisions of the section 21 Legal Services Authority 1987. All other provisions of the Act apply regarding the dispute of the Lok Adalat. And other one is judicial settlement. The court only will make a reference to whom? Sustainable, suitable institution or persons. Such institution, person shall be deemed to be Lok Adalat. In this case also, case is referred by Lok Adalat or any other judicial institution. Because special court may be set up only to sort out the differences. Case is referred by whom? Court only. And the last one here, mediation. The court only shall effect the compromise between the parties, shall follow the procedures accordingly. Right? So in case of arbitration, party. In case of a Lok Adalat judicial, court will make a reference. In case of a mediation, court will appoint the mediator if you want for the sake of settlement. And Civil Procedure Code 1999 by the section 89 amended, in the code amended according to new section 16, court fees according to 1870 shall stand as follows. Remember, I filed a case against you, you filed a case against me, I paid the court fees already. How much fees I paid? Say 10,000 rupees court fees paid. Trial going on. Example sake I am telling. Trial going on. In the meantime, parties wanted to sort out issue outside the court through either arbitration or a Lok Adalat. Affidavit filed, court permitted. Go ahead. What about my fees? I have already paid the fees. I thought I can settle through court. Now, total refund. Whatever amount you have paid, that will be refunded. That is the next pair. Refund. Refund of the fees. When court refer, see here, court is giving a reference then only. When court refers to parties to the suit of any person, any one of the mode of settlement for the dispute under 89, that is above methods, arbitration, lok adalat, judicial settlement, otherwise mediate. In that case, according to Civil Procedure Code, the plaintiff means party suffered, shall be entitled to get a certificate from the court authorizing him to receive back from the collector the full payment of the fees paid to such plaint. Means in this case, whatever may be the money I have paid, I can claim back. Who should pay? District collector will pay money, because treasury transactions, the court won't pay directly through the district payment. District collector is the treasurer to sign the payments for that side. Okay, now it is arbitration. Now onwards, first arbitration, very lengthy fashion they have given it. The remaining all only 2 to 1 paragraphs only. Arbitration. Arbitration means, remember, settlement. Arbitration means settlement. Whenever there is a dispute between the two parties, if you want to sort out your issues or disputes outside the court amicably, you can sort out. For that, what you have to do? There are certain things you can pursue. Just I will read out quickly. Arbitration is a form of ADR, a technique for the resolution of the dispute outside the court, where parties to a dispute refers to one or more arbitrators. Time being, we remember, you and me, there is a dispute. We want to settle the case through arbitration. Who will appoint arbitrator? Both of us with the consensus can appoint one arbitrator. Or I will appoint my arbitrator, you will appoint your arbitrator. Now two arbitrators are there. Both will appoint third arbitrator. Always remember, arbitration, we have the not even number arbitrators, uneven number arbitrators required. Why? If vote is conducted, resolution has to be passed. If 4 are there, both are divided equally, how to pass the resolution? 10 are there, 5, equal number. 8 is there, 4, even number not allowed. Nothing but uneven numbers other than the even. Like 3 odd numbers are there, 3, 7, 15, 13, odd numbers are there. Definitely majority will come. Decision can be taken. So, disputing party, both the parties will appoint one arbitrator. Then again, both the arbitrators will appoint one more arbitrator. That third arbitrator is called presiding officer to listen case from both the arbitrators. I appointed him as an arbitrator. You appointed him as an arbitrator. Both the arbitrators will appoint another person as an arbitrator. That person will become presiding officer. Are you understanding what I am saying? In simple example, there is a dispute between X and Y. X appointed A as an arbitrator. Y appointed B as an arbitrator. Both of them together will appoint C as an arbitrator. Now C is called presiding officer. So arguments will be made before whom? C. A will make his own argument. B will make his own argument. At the end, all arbitrators put together, they have to take with the consensus one decision. How to come to one conclusion. Are you sensing? So arbitration agreement, even one arbitrator may be there. If a parties agree, both agreed X and Y, we appoint P as a arbitrator. With a consensus, one person can sort out. When there is a different people that, I want to appoint my own person, you can. But arbitration tribunal consists of only one arbitrator. Is the decision is final. No argument on that. Okay. So arbitrators will be appointed. Arbitration agreement will be there. In arbitration, always arbitration agreement plays important role. In agreement, terms and conditions will be there. What are the disputes can be referred, when it can be referred, details of the partners, details of arbitrators, all the terms and conditions will be decided. And within the time bounding program, person will be resolving the issues. Now let us see here. Advantages of arbitration. What benefits we have? often faster than litigation. Court will take its own time, arbitration come, judgment quickly. And arbitration proceedings and arbitration award generally non-public, means it happens in a confidential manner. Within the four walls, 2 persons to 3 persons will sit and discuss. Court process is the open hall. Any person can walk into court and see the proceedings. And nowadays, online available cases, Supreme Court and High Court arguments you can see. So there is no confidentiality. How the process is going on, everybody can access there. But that is not the case in case of arbitration. Non-public and it can be confidential. What it was there, confidentiality can be maintained. And if the subject matter of the dispute is highly technical, arbitrators with the arbitration degree of the expertise can appoint one, cannot choose the judge in litigation. When technical nature, you can't take a decision. You should go to the technical consultant, and accordingly, we have to go for the conclusions as such. Arbitration Conciliation Act 1996 lays down the provisions relating to arbitration and conciliation procedures. Without arbitration agreement, usually recourse to arbitration does not happen. So like a partnership, if you want to start a partnership, agreement is must. Otherwise, section 13 of the Partnership Act we have to follow. Similarly, in case of a LLP agreement is there. If not, Schedule 1, rights and duties of the partners are defined. Similarly, here also. LLP agreement mean in case of arbitration means arbitration agreement is must. Now guys, section 7, what are agreements mean? Arbitration agreement. In this part, arbitration agreement means an agreement by parties to submit this arbitration to arbitration all or certain disputes which may arise between them in respect of the defined legal relationship, whether contractual or not. An arbitration agreement may be form of arbitration clause, nothing but an agreement, one clause will be there, case can be referred for arbitration, that's called arbitration clause. And the contract or the form of the special agreement. Arbitration agreement must be in writing, it can't be oral. And arbitration agreement in writing, if it is contained, the document signed by parties, both the parties have to sign the arbitration agreement. Exchange of the letters, telex, telegrams, other means of the communication, nothing but to establish that they are into contract. They are into agreement. Some kind of evidences we have to generate. And electronic media through the recorded agreement or exchange of the statement of the claim, defense which the existence of agreement is alleged by one party, not denied by other party. And a reference to the contract to document containing arbitration clause constitutes an arbitration agreement if the contract is in writing and a reference such as to make arbitration clause a part of the contract. So in agreement itself, this is one of the clause and all conditions are there. In case of a dispute, case can be referred to arbitration. So for total summary is nothing but a arbitration agreement must be in writing. In agreement itself, there should be arbitration clause. That's it. This is the only summary here. Now, section 8, power to refer parties to arbitration where there is a arbitration agreement. Judicial authority before which an action is brought in a matter which is the subject matter of arbitration shall, if any party, arbitration agreement or a person claiming through under him applied not later than the date of submitting his first statement on the substance to the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or a court, the parties refer this case unless it is found prima facie valid arbitration agreement exists. Nothing but before final judgment, you must establish a proof in the court of law that we had a arbitration clause. Prove it. Then you can go for arbitration. Otherwise, court will listen the case. And application referred above shall not entertained unless it is accompanied by original arbitration agreement, duly certified copy thereof. Arbitration agreement you have to produce above case, otherwise other Supreme Court or a court judgment is going to be enforceable. Provided, above point only continuation, that where the original arbitration agreement, certified copy thereof is not available with the party applying for the reference to arbitration as above, the said agreement or the certified copy is retained by other party to that agreement, then the party applying for the file a application along with a copy of arbitration agreement and a petition praying the court the call upon the other party to produce the original agreement and is duly signed before the court. Means already we are entered into an agreement copy with you. I don't have the copy. In agreement there is a arbitration clause. Later when dispute has come, you filed a case straight away rather going for arbitration. Then as a party, I pray the court, we had entered into contract. In agreement, there was a clause of arbitration. Let other party produce the original document to know whether we are having any kind of arbitration clause or not. If I don't have evidence, I can pray the court, give a direction to him to submit a original document. You will come across that. Because sometime I may lost my paper, I don't have any evidence. I can pray the court, look into this matter in this manner also. And the third one, notwithstanding an application has been made under the above first case and that issue is pending before the judicial authority, an arbitration may be commenced. Case is pending before the court, but still arbitration can be commenced when or continued such arbitration are made, making appointing arbitrators as mentioned in the act. Though case is pending before the court, you want to sort out the case amicably outside, arbitrators can be appointed. Then we will submit a case affidavit that we want to withdraw the case, we want to refer this case for arbitration. Court will permit. And other one, section 10. What is section 10? Number of arbitrator. Parties are free to determine number of arbitrators provided such manner shall not even number, shall not be in even number. Means 4, 8, 6 even number should not be there, odd number can be appointed. And failing the determination of the above, the arbitration tribunal shall consist of only sole arbitrator. I told you these words. Section 11, appointment of arbitrators. A person of nationality and may be the arbitrator, means citizen of India can be appointed as a arbitrator unless otherwise agreed by parties. Generally, citizen of India will be appointed. A foreigner doesn't know about local laws, how can he judge on that thereby? And subject to the above, the parties are free to agree procedure for appointing the arbitrator or arbitrators. What procedure? According to agreement. And failing an agreement referred above, arbitration with 3 arbitrators, each party shall appoint 1 arbitrator and 2 arbitrators shall appoint 3rd arbitrator who can act as a presiding arbitrator. Nothing but like a presiding officer to listen from both the arbitrators. If appointment procedure in above, the party fails to appoint an arbitrator within the 30 days on the receipt of the request to do so from the other party. If I fail to appoint within the 30 days, for example, dispute between you and me, you are appointed the arbitrator within the 30 days. If I am failed to appoint an arbitrator, you can appoint another person as an arbitrator. You also can help me out, not that always I should appoint. Okay. And 2 appointed arbitrators fail to agree upon the 3rd arbitrator within the 30 days, from the date of their appointment, appointment shall be made request by a party to the Supreme Court, or as the case may be, High Court, or any person or institution designated by the court. Third arbitrator has to be appointed. Myself is one arbitrator, you are another arbitrator. We should appoint a third person. We don't have the consensus about the third arbitrator. Then we can go to Supreme Court or a High Court or any person for appointment of a third arbitrator for the sake of acting as a presiding arbitrator. Failing an agreement with the referred above, an arbitration with the sole arbitrator, if the parties fails to agree upon the arbitration within the 30 days from the date of receipt of request by one party from another party, so agreed appointment shall be made by on the request of the party, the Supreme Court or the High Court or any other institution can appoint. If I fail to appoint, I can ask the Supreme Court or High Court or any institution appoint arbitrator. I can ask the co-arbitrator, otherwise I can ask the any court also on my behalf, suggest one arbitrator. Where under the appointment procedure agreed upon by parties. If the party fails to require under the that procedure, you have agreed, later fail to fulfill it. And the parties, two or more arbitrators, fail to reach the agreement expected under the procedure, or a person including the institution fails to perform the functions entrusted to him under the procedure, the party may request either any of the court or Supreme Court or High Court or a designated court to make the necessary measures, unless agreement on the appointment shall be upon the means of the securing the appointment. The Supreme Court may or a High Court or a, while considering the application under the above, the notwithstanding anything, any judgment, decree or a court order confined to the examination of existence of the arbitration agreement. If there is no arbitration agreement, arbitrators were not appointed, then court to Supreme Court or any institution referred by the court to shall appoint the arbitrators. So in simple, arbitrator can be appointed by disputing party, arbitrator can be appointed by third person, arbitrator can be appointed by Supreme Court, High Court or any institution as referred. That is summary of whole paragraph. And now decision on the matters entrusted to the above 4 and 5. Of course, the designation of any person, institution of the Supreme Court, these are all same terminology and there is no much on that. A decision on the matters entrusted above, the Supreme Court, as the case may be, or a High Court or any institution designated, is the final, and no appeal for the letter patent appeal against the decision. You filed an application to Supreme Court, High Court or institution or any person to appointment of the arbitrator. They appointed. For that, no appeal. You can't say, no, I don't want this person as arbitrator. Your job is to make an application. Once appointed, once for all appointed, you can't ask that change this person as an arbitrator as such. So now guys, this is about arbitration side. Arbitration means settlement. Now conciliation. First listen 2 minutes. Whenever there is a dispute between the two persons, to sort out the dispute, the first and paramount important and conciliator. Especially employee and employer, whenever there is a dispute. To sort out the dispute between the employer and employee, first conciliation officers will be appointed by appropriate government. Between the two persons a dispute is there, disputing parties may appoint the conciliation officer. 2 or more persons can be appointed as a conciliation officer. You and me dispute. Both of us together can appoint one person as a conciliation officer. Or you appoint every person, I will appoint my person like a arbitrator. And they will appoint one more person as a third conciliator, as a presiding person. And proceedings will go on. The conciliation officer will listen from both myself and from her point of view. He will see my evidences, he will see her evidences. Finally, based on the facts and circumstances, he will give one decision. That is called memorandum of settlement between disputing parties. If he is able to bring the settlement, he has to prepare memorandum of settlement. Problem is resolved. For example, if they fail to reach one settlement, then he has to prepare memorandum of non-settlement of agreement between the two parties. What are the steps the conciliation officer made to bring a settlement? What are the areas of the differences? Total say 10 areas are there. Already 8 areas they have a consensus. Regarding the 2 areas, both fail to reach one consensus. Hence, there is no memorandum of settlement. He has to draft clearly in the following areas they fail to reach one consensus. From the date of conciliation officer is appointed, within the 14 days, issue has to be settled. See the time and 14 days time. Very quickly it will be done and report is submitted. Settlement is there, memorandum of settlement. No settlement is there, memorandum of non-settlement of agreement. Reasons for non-settlement. Remember, when conciliation fail, then only arbitration. Am I making sense? When conciliation fail, then only arbitration. When arbitration fail, then mediation. It's a stages set like that. Okay? Now let us see one side. Conciliation is a ADR process whereby parties to the disputing use the conciliator who meets the parties separately in order to resolve the differences. Person is appointed, he meet the disputing parties separately, he listen from both the persons. They do this by interpreting the issues with the technical assistance, exploring the potential solution and bringing about negotiated settlement. Conciliation is a voluntary where parties involved agreed and chosen to resolve the differences by conciliation. It is a voluntary act. True or false? And this process is flexible, allowing the parties to define the time, structure, content of the conciliation proceedings. And the proceedings are not public, confidentiality can be maintained. Conciliator have, when proposing a settlement, taken into account the legal, commercial, financial positions of the parties. Just like that, he want to pass the resolution looking at the parties' ability to pay and settlement will be settled. Conciliator is usually trained, qualified neutral person who facilitates the negotiation between disputing parties. Conciliation involves discussions among the parties and conciliator with the aim to explore the sustainable, equitable resolutions by targeting existence of issues involved in the dispute and creating positions for settlement that are acceptable to parties. The process is risk-free and not binding the parties till they arrived at sign the agreement. Since memorandum of settlement prepared does not mean that problem solved. Unless both the parties are not signed, this is not approved. And according to this procedure only, one conciliator is appointed to resolve the dispute between the parties, and the parties can appoint a sole conciliator for the mutual consensus if there is no bar. There is no bar appointment of the 2 or more conciliators, and in conciliation proceedings with the 3 conciliators, each party appoint one conciliator, third conciliator act like a mutual consent. Unlike arbitration, the third conciliator officer is here presiding arbitrator. The third conciliator is Not so. Conciliator is supposed to impartial and conduct the conciliation proceedings and impartial manner. He guided to the principles of objectivity. Objectivity means unbiased opinion, into fairness and justice, and by using his trade concern and circumstances of the disputes, including a previous business practices between the parties, the conciliator is not bound to rule the procedures and evidence. The conciliator is not bound to rules of the procedures and evidence. Conciliator does not give any award of order. Conciliator, no consensus arrived between the party. Conciliation proceedings fail and parties then can report to arbitration. That's why I said when conciliation fail, arbitration start. But one point you remember, both are appointing the one person as a conciliator. Third conciliator is not a presiding officer. I think I said it as a differently. Please remember that. And he is not a presiding conciliation officer. Remember this point. He is not going to be the presiding person. Fine. So this decision is not final. When conciliation fail, then arbitration starts. Yes, this is about conciliation. If you reach the conciliation officer cannot provide any kind of a award or order. I told you, conciliation officer prepare what? Memorandum of settlement between the parties if there is a settlement. If there is no settlement, the memorandum of non-settlement between the parties will be prepared. Memorandum of settlement or memorandum of non-settlement will be drafted. Okay, na? This is about conciliation. So conciliation is an ADR with a view to resolve the dispute between the two parties. Conciliation officer, nothing, conciliation process is a purely voluntary and nowhere in agreement it is not there. Conciliation officer, sole conciliator can be appointed to solve the issue, or each person can appoint the one conciliator. They can appoint a third conciliator. The decision taken by the conciliator is called as a memorandum of settlement between the disputing party. In case of a non-settlement, memorandum of non-disputing between the parties. And this is not a award, this is not a court order. And finally, this is any aggrieved party not satisfied, he can further refer the case. So, when conciliation fail, you can refer to the arbitration. Okay? And last one is here, last but one, mediation. What is the mediation? Friends, remember, India versus Pakistan. There is a dispute, long pending issues are there. If you remember, US, United States of America, always make one proposal to Government of India. I want to act as a mediator. I want to act as a mediator. You people can sort out our issues. Government of India said, we don't want. We know how to sort out our issues. What a mediator will do? Friends, remember, a mediator is a purely facilitator. He is only facilitator. Means he make arrangements. Disputing parties will meet under one roof. He make only arrangements. He is not a part of the problem solving. Understanding? Whereas the conciliation officer, not like that. He will discuss with the disputing parties. He will listen from you, he will listen from me, and finally he make proposal. Finally settlement will come. Whereas mediator never involved into settlement process. He is only facilitator. For example, there is a dispute between both of you. I call, come for settlement. I act as a mediator man. Tomorrow morning 10 o'clock come to so-and-so hotel, room number so-and-so. I am only facilitator. I am not sitting between both of you also. And you people have to sort out our issue. That's why Government of India always say, we don't want. Mediator, what's the purpose of mediation and facilitation? Can't we arrange our own arrangements? If really problem is there, can't we sort out? That's why mediator role is very, very nominal, and he is only facilitator, bringing the disputing parties under one common platform. That's it. Later issues we only should sort out. But the decision taken by mediator is not final again, because whatever the settlement reached between both of them, he won't play any role here, right? Let us see. Dispute settlement through mediation, again voluntary and a relatively informal process of the disputing resolution. It includes a party-centric approach where the neutral third party assists the parties amicably resolving their dispute using the specific communication negotiation technique. Involvement of the parties to the control over the whole process is peculiar to the dispute resolution method, and the mediator only act as a facilitator. Okay, facilitator helping the parties to reach the negotiable settlement disputing parties. Mediator makes no decision, no award. This mediation process, each sides meet an experienced neutral mediator. Otherwise, the session begins with each side describing their problem and resolution by desired, which it is eliminated by conducting the separate or a joint meeting, communicating finally arrangement by both the parties. Advantage of mediation is that agreement in which the parties themselves disputing is quickly resolved without great stress and expenditure. Relationship between the parties are prevailed and the confidentiality is maintained. So mediator is only a facilitator. Remember, he is not a part of the problem solving. Other one is Lok Adalat. Lok Adalat, otherwise the People's Court, have been established by the government to settle the disputes by way of the compromise or a conciliation. This is another way of alternative ADR that has been provided for. It is the judicial institution, a dispute settlement agency developed by the people themselves for the social justice based on settlement or compromise reached through systematic negotiation. Lok Adalat concept, even the cases pending in a regular court within their jurisdiction according to 89 of the Civil Procedure Code, for the referring to disputes to Lok Adalat, therein provisions of the legal services under 1897 is applicable. Lok Adalat courts are there, court can refer that case to Lok Adalat. So, ADRs are nothing but a conciliation, arbitration, mediation and Lok Adalat. Judicial settlement, nothing but a Lok Adalat and all. This is about ADR. And this is maxim, this we have to read and words we have to give one. Maybe one question may come, who knows? See this, some words already we know. Caput emptor, corpus means we know. Defecto in the director's chapter, defecto, de jure, diminis, devo, dectum in the consideration chapter. Estoppel meaning we know, pretending from, denying, ex gratia, ex officio, ex parte, ex posto. Yesterday we have done ex posto, and factum. One case for consideration part we have done. Habeas corpus we know. Ispo pass in lieu of. Some statements prepared, inter alia, personam, rem. No, when you read one time, you will understand what I know in this. Isn't it? Malafide means ill intention, mens rea, guilty mind. Mutatis mundadis, as it is, I said. which is necessary changes having been. Novation, contract law, and this already we have done yesterday. Anonymous, pari passu we know, per se we know, prima facie, quantum merit you know, quid pro quo you know, quo warranto you know, warranto necessitates you know, residendi we know. Just give one reading and it won't take much time, it won't stress you also. Sine die. Sine die means indefinitely postponed. Parliament or assembly last day, the notification is this house is sine die. Sine die means indefinitely postponed. When is the next meeting, we'll send a notice to you. Vis major, vice versa, waiver, Tomoto, Euroberi Fedi, utmost good faith. We know something already. Only thing is, patiently for 15 minutes if we read all the points, where you have to remember, there is nothing that you can buttify. One reading will help you out to have the meaning. So, this is about my part. So, 1 month before, exactly 1 month before examination, your syllabus is done. Day 1 I used to say one word, prepare along with me. If you have really prepared along with me, today I said my syllabus is done, and tomorrow you should say my preparation is done. That is the advantage. And you have to trust us, man. Sometimes you have to trust the faculty. Isn't it? If we prepare, who will gain here? Will I get any benefit out of it? No. Focused areas we know and accordingly prepare. If you see the very first page where you have to go for your concentration of this one. Okay. This keep in mind. This will help you. Where should I focus? Where I can take some chance on that. See that code of wages weightage is only 5 marks. Certain things and I should not say louderly. I am talking about my personal opinion. I am not generalizing anything. I request all the students to prepare all the subjects, all the topics. No, don't take any choice. If I write examination, how do I write? Because I pass through that stage only. I attempt for 80 marks. I get to 75. That's all. I attempt only 80. I never dreamed that I should attempt for 100. No. I never give importance for I should eat everything there, whatever is there in front of me. No, I am choosy. I am a very choosy person. When I go for outside for any party, dinner and all, lunch, I won't take a regular diet. Every day what I eat, I won't eat there. Which I won't every day, something different, some items will be there. Those items only I will eat. Remaining all every day I am eating. Rice I am eating, biryani I am eating, sambar I know, curries I know. Why again same thing? Something differently is there. Chaat is there, ice creams are there. Try differently. Some students are there, they attempt for 100 marks, they get a single digit marks. Some students attempt only 90, they get 80 and they attempt 90 and they get 70 and they attempt 90 and they get 60 and they attempt 90 and they get at least 55 and they attempt 90, they get 50 and excellent, sir. Excellent and I appreciate them. My personal opinion again, I won't encourage that, but one should have a gut feeling. Gut feeling sense, any topic I prepare in such a way, if I write, I should get full marks. The examiner also should think 2 times, shall I reduce marks or not? That is how I prepare. That's why I never give importance for 100 marks to attempt. I attempt 60, I get to 60. Gut feeling and challenge, man. This is the age. Sky is the limit. Never forget it. For your effort, sky is the limit. Nobody can stop you. Nobody can stop you, man. Do your best. Give your best. End of the day, don't forget only one thing. I believe in only one thing. You are going to be brand ambassador for your family. That's it. The way you succeed matters. It matters. At old age, how do you want to see your parents? Now you can decide. How do you want to treat them at old age? With the comfort zone? I want to treat my parent as a kid. 3 years baby, 1 year baby, 1 day baby, what care we give? That care I want to take my parents when they become old. For that, I should settle now first. If I am only struggling, how can I take care of them? I want to give everything for them in their life. They sacrificed everything for my sake. Many times they compromised in their life. I am talking about a middle class. They compromised many times in their life. They should not come where they compromise again. They feel that end of the day, they lived their life most successful manner. They groomed the children in such a way, they should have a satisfaction. When you well settle in the life, parent feel that, yes, as a parent, I am successful. I am able to show a right path to my child. What is the purpose of life, Andy? Next generation should be happy, isn't it? What problem my father is facing, same problem if I am also facing. What is the difference between generation to generation? Tell me. There is no improvement. Certain things will come in the life, and remember, until your studies are completed, stay away from wine and other type of activities. That is the idea. There is a time for everything. First acquire one qualification. Have qualification first. It is like a Brahmastra in your hands. With this, the way you look at your life will be different. I am not exaggerating. And one qualification in front of your name, if there is the word CMA Nitya, it gives a sounding in such a way and give a confidence in our life, you never forget it. You are not dependent on anyone, man. You become independent, professional. Money comes like a tsunami. I am not exaggerating. This is the truth. You need not worry for money. Money will come. It will fall. Never ever work for money and do your job very sincerely. Money follows you. When you start running after money, it won't. That's why you do your work most committed manner. Give the best, man. But as a student, and right now I would say only one thing. I always look at my parents, and whenever the student, always I see my parents only. My mama used to say only one word, beta, you should be settled in the life. That's it. Who was my first lover? My mother. My first lover, and she loves me in such a way, without seeing me started loving me, isn't it? How I am going to be boy or girl, she don't know, but keeping her hand on the stomach, my baby. Such a lady. wonderful lady, want to asking only one thing, beta, pass exam. Can't I give that? Am I incompetent that? What they were asking, not money. They were asking, beta, pass exam. Are we so incompetent, inefficient to give back that? And they were asking crores of rupees money, means you can say, no, this is not correct. They were asking, beta, pass exam. If you pass exam, who will get benefited? You. Not your amma. Hello. She was very happy with what she has today. She don't want anything. Mother in the sense, parent, what I am saying. So we should succeed in such a way, guys. Time being, our distractions, please postpone. Like a horse and horse going on, if you notice, the horse eyes were closed like this. ఎప్పుడైనా చూసారా? దానికి ఇట్లా కట్టేస్తారు. ఒక డెకరేటెడ్ హార్స్, ఐ డోంట్ నో హౌ మెనీ ఆఫ్ యూ సీన్. ఇట్లా పెట్టి, ఎందుకంటే బ్యాండ్ వస్తుంది, సౌండ్ వస్తుంటుంది, డిస్ట్రక్షన్స్ ఉంటాయి, అది బెదిరి పారిపోతూ ఉంటుంది అటు ఇటు, అందుకని ఇట్లా పెట్టేస్తారు. అంటే నో డిస్ట్రక్షన్, ఫోకస్ ఓన్లీ ఆన్ ద డెస్టినేషన్. సింపుల్ అండి. మనం కూడా అంతే, ఇట్లా sacrifice everything here. No friends, no social media, no TV, nothing. Like this we are going to live for lifetime. Huh? No. Maybe for 2 months, 1 month, 3 months, 5 months. Don't forget it. Any student started the preparation of the examination at least for 5 months and pakka they will pass and I will write on a bond paper and give. But honesty is important. Don't cheat yourself. When I am going to my reading room means I mean it. I mean it. కొన్ని పదాలు మనం చాలా క్లియర్గా చెప్పాలండి. నేను అన్నాను మీరు మంచివారండి అని. ఐ మీన్ ఇట్. అంటే ఈరోజు ఒక మాట చెప్పి 1 వీక్ తర్వాత ఇంకో మాట చెప్పడం ఉండదండి అక్కడ. ఒకే స్టేట్మెంట్ ఇస్తాం. ఆ స్టేట్మెంట్ ఇచ్చే ముందు 100 సార్లు ఆలోచించండి. ఆ తర్వాత మీరు చెడ్డవారిగా మారిపోవచ్చు కూడా. మరి నా దృష్టిలో మీరు మంచివాళ్లే, మీరు ఎప్పటికీ మంచివాళ్లే. అందుకే స్టేట్మెంట్ తొందరపడి ఇవ్వకూడదు మనం. ఐ సెడ్ ఐ లైక్ యూ, ఐ మీన్ ఇట్. నాట్ 1 డే, లైఫ్ టైం. తర్వాత మీ లైఫ్లో ఏమైనా కావచ్చు, అనవసరం. నా దృష్టిలో మీరు మంచివాళ్ళు. ఆ తర్వాత ఏమో జరిగిందో నాకు తెలియదు. నా దృష్టిలో ఎప్పటికీ మీరు మంచివాళ్ళు. అట్లాగే చదువు కూడా రీడింగ్ రూమ్కి వెళ్ళామండి. ఐ మీన్ ఇట్. ఐఎమ్ దేర్ ఇన్ ద రీడింగ్ రూమ్ ఓన్లీ టు స్టడీ. ఐ మీన్ ఇట్. ఐఎమ్ నాట్ యాక్టింగ్, ఐఎమ్ నాట్ ప్రిటెండింగ్, ఐఎమ్ నాట్ చీటింగ్. At least we should be loyal to ourselves. We should be loyal to our parents. And be honest. And don't forget, my dear, for some people success will come in the very first attempt. For some people success may test you. No problem. But never ever give up. Never ever give up, because your life. Once you give up, you become follower. Race ki veltunnamanడి andaram. You are going for the race. If you are in the race until the last minute, you will get 1 rank. Either first rank or last rank, I don't know, 1 rank pakka. But you should be in the race. If you are out of the race, you become clapper for lifetime. I have chosen this path and CMA. I am working on that. It is the race. All of you pass in first attempt. For me, take a second time. It may take a third time. Have patience. But correct yourself. What mistakes I have done in the last exam, don't repeat. I am not saying that this is going to happen. No. I am very optimistic person. And I am giving a confidence for you that never ever give up. Take a chance. And today also 1 month time and exactly 29 days time ఉందండి మీకు. ఒక మీ 9 days తీసేస్తున్న 20 days టైం ఉందండి. ఈ 20 days ఎవ్రీడే నేను 10 hours చదవగలిగానంటే 290 days, 90 hours టైం ఉంది నాకు. ఐ కెన్ ఈజీలీ రీడ్ ఎవ్రీథింగ్. ఈ రోజు మొదలుపెట్టినా నాకు ఛాన్స్ ఉందండి పాస్ అవడానికి ఎగ్జామ్. నేను 290 hours టైం ఉందండి. 4 papers నాకుంది. షెడ్యూల్ వేయండి. You have to arrest yourself in a room. Self-arrested. Like a Ayappa Mala people will take, like that now season. Already people started Ayappa Diksha. You take CMA Diksha. చదవండి. ఇప్పుడు కాకపోతే ఇంకెప్పుడు చదువుతారు మీరు చెప్పండి నాకు కదా. యంగ్ ఏజ్, దిస్ ఇస్ ద ఏజ్. ఎందుకు ఇప్పుడు మీకు ఏమి టెన్షన్స్ లేవు, బర్డన్స్ లేవు. పేరెంట్స్ ఆర్ ఎంకరేజింగ్. పేరెంట్ ఎంకరేజ్ చేస్తున్నప్పుడు గెట్ ద హైయెస్ట్ క్వాలిఫికేషన్ అండి. వాళ్ళు మనల్ని ప్రెషర్ పెడుతుంటే నో స్టడీస్కి మీరు సపోర్ట్ చేయము, పని చేసుకోవాలంటే కష్టం అండి. దే ఆర్ రెడీ టు సపోర్ట్. యూజ్ దట్. గెట్ ద బెస్ట్. But later, don't cry that I don't have opportunity in my life. Opportunity won't come every day. Hello. Environment will change. Accordingly, conditions will change. Sometimes, today conditions are in our favor. Favorable conditions are there. Grab it. Tomorrow conditions may be unfavorable. Who knows? We don't know tomorrow what may bring. So when conditions are favorable, parents are supporting, study. There is no other way. Get the best of the best qualification. Remember, if you pass exam, you are going to settle, not your parent. Simple logic. If I eat, my stomach is going to fill, not my parental stomach. If I study, I am going to qualify. I am going to have a comfortable life. It is me. I can change my life, not others. ఎప్పుడు కూడా మీరు ప్రెషర్ చేసుకోండి. యూ పుట్ అండర్ ప్రెషర్. మీరు 8 hours చదవాలంటే 10 hours చదవండి. 10 చదవాలంటే 11 hours చదవండి. యూ షుడ్ ఎక్సీడ్ దట్. అంతేగా 10 hours అంటే 5 hours అది క్లోజ్ చేయకండి. యూ షుడ్ హ్యావ్ ఆల్వేస్ 10 అంటే 11 hours ఎక్స్టెండ్ అవ్వాల్సిందే అది అట్ ఎనీ కాస్ట్. నో కాంప్రమైజ్. ఎన్ని రోజులు చదువుతాం అట్లా? 1 month. ఆ తర్వాత నాకు రిజల్ట్ రావడానికి మళ్ళీ టైం పడుతుంది. I have relaxed. 1 week చాలు కదా రిలాక్సేషన్ కోసం. అగైన్ బికమ్ నార్మల్ రొటీన్ లైఫ్. మనకు అప్పుడు మీకు బోర్ కొట్టేస్తుంది, ఏం చేయాలరా బాబు అని. సీరియస్లీ గైస్, సిచ్యువేషన్ డిమాండ్స్, డూ ఇట్. ఐ థింక్ మీకు అందరికి ఒక ఈగల్ స్టోరీ చెప్తాను ఎప్పుడు, చిన్న స్టోరీ, కొంతమందికి తెలుసు, బట్ స్టిల్ ఐ రిమైండ్ యూ. ఈగల్ స్టోరీ అండి. ఈగల్స్ లైఫ్ ఈజ్ ఫర్ 70 years. ఇట్ లివ్స్ ఫర్ 70 లైఫ్ స్పాన్. After 30-35 years, feathers become heavy. పెద్దగా అయిపోతాయి feathers. And this nose will be like this. Original nose ఎలా ఉంటుంది? That nose over a period of time, lower part will go inside, upper part will grow, and it will bend like this. Next time you see eagle, and the nose will be down like this. And it can't pick the food also, because if it is like this, I can pick easily. When it's going like this, I can't pick the food also. I can't carry the food, I can't fly high because heavy feathers. Now eagle has to take a decision. Whether to die with this body or to become normal. To become normal, what to do? Painful process. Very painful process. It will go to the hill station. Where little nearby water is available. What it will do? First to remove all the feathers then by itself. All the feathers it removes. Bleeding. Literally bleeding. When you are removing your hair literally like this, it bleeds or not? Hey, bleeding. Finally, it breaks the nose. It is grown like this. It has to broken. Bleeding. It can't fly. It can't eat food now. Only food is water. It will be there for like the 15 to 1 month. And only water is the food. Enemy attack may be there. It may die also. No problem. It will live like that. After 1 month, it flies like a just newborn eagle. Lives for another 35 years. అంటే one eagle able to take a decision for a life comes, I wanted to live in a best way. Ordinary bird got such a willpower to live in a best way. Can't we remove our lethargy? మన లేజినెస్ని మనం పోగొట్టుకోలేమా? అంటే అందరం అనుకుంటామండి, ఎవరి కోసం చదవాలి అంటే ఒక్క ఇన్స్పైరింగ్ అంటే ఏమంటాం దాన్ని, వాట్ ఈస్ మోటివేటింగ్ యూ టు స్టడీ? పీపుల్ సే, వై ఆర్ యూ స్టడీయింగ్? అండ్ ఐ వుడ్ సే మై సేక్. కొంతమంది అంటారు మై పేరెంటల్ సేక్. తప్పులేదు, చదవండి ఏదో ఒకటి, ఎవరో ఒక ఇన్స్పైరింగ్ ఉండాలి కదా మీకు. నువ్వు ఎందుకు చదువుతున్నావయ్యా? మై మామా సెడ్ బెటా యూ వాంట్ టు పాస్ ఎగ్జామ్, ఐ వాంట్ ఇంప్రెస్ మై మదర్. My dad said, better you have to pass exam because of my dad. Dad never asked anything. All 20 plus years he is giving only, never asked him anything. First time he is asking, better pass exam. Now I am already 50 plus. I am also growing old. When you become elder, parents are becoming older. It's a time. You have to take the family responsibility, isn't it? How long he can work, and already worked for 25 years, that man isn't supporting the family for last 25 years. Nobody asked the dad, how are you, man? Nobody will ask the dad, especially mother. At least we have some closeness, especially with the dad. Nobody will question. Father is isolated person in the family, and trust me, children are along with mother, they will travel. They got a fear to talk with the dad. They keep the distance. He wanted to share many things with the next generation, but hardly people come and sit. Hardly people talk to him. They pretend as if they have a fear in their mind. Isn't it? He is asking, man, 20 years, never asked anything. Maybe occasional telling study, that's all. Beyond that, he won't say anything. First time he is asking, better, now I am also 50 plus man. It's a time that we have to settle. At least to fulfill his wish, can't we do some favor? మనం ఎవరినో ఉద్ధరించాల్సిన అవసరం లేదండి, మనల్ని మనం ఉద్ధరించుకుంటే చాలు. I need not to do favor to anyone. I will do favor to myself and for my family. If I succeed, my family will succeed. If I failed, my family also will suffer end of the day. I can't give whatever they want. Days are coming today in such a way, one person is coming means people are calculating how much it costs if he stay in my house. Sorry to say certain things, people are counting on. If we come and stay here for 1 week or 10 days, how much money we have to spend? Day should not come, we should not count that money. We should grow above that level. Your bank balance always should be minimum 1 crore you have to maintain. Think big, man, always. Cash balance 1 crore should be available. Cash, not in the form of assets. Cash should be, means if dad want better, I want to go to Europe and have a cup of coffee. Buy a ticket and go, dad, go. Go, man. No second thought in that. How long we can compromise and live life? And they compromised for 55 years, that man compromised already. Can't we give at least some memorable life for him? When he look back once, at least some memory should be there. What is the great memory? What we can give for them? When you well settle and give one ticket for your parents, both of you go to world tour. I made arrangements. Is it not achievement in our life? And how you see, they imagine that parental happiness and my children settled. They won't expect anything, sir, not even thanks from you. You are studying means for your sake only. Never ever forget, not only now, entire your life, and one word never forget, you are the brand ambassador of your family. Ante. You are the role model. నేను చూసి మిగతా వాళ్ళందరూ కూడా షుడ్ ఫీల్ జలస్. అయిగోని కడుపమంట అంటాం కదా, బా ఏం లైఫ్ అండి వెళ్ళదు అసలుకి. ఎలా అయ్యారు ఇంతగా సక్సెస్ వీళ్ళు లైఫ్లో? ఎలా హౌ డస్ ఇట్ పాసిబుల్? మనం అనుకుంటున్నాం కొంతమంది చూసి, ఏం లైఫ్ అండి, విరాట్ కోహ్లీని చూస్తాం, అందరూ అప్రిషియేట్ చేస్తాం. వావ్, వాట్ ఏ ఫిజిక్, వాట్ ఏ మెయింటెనెన్స్. మరి మీరు చేయండి అట్లా. ఎవడొద్దన్నాడు? ఎవరొద్దన్నారా? యూ కెన్ బి హెల్త్ కన్సర్న్ పర్సన్ ఆల్సో. యూ కెన్ బి హెల్దీ, యూ కెన్ టేక్ ఎ హెల్దీ ఫుడ్. వీ థింక్ దిస్ మున్సిపాలిటీ డబ్బా, వాట్ ఎవర్ వీ సీ వీ డ్రాప్ దేర్. అంతే కదండి. ఆయన చేసే హార్డ్ వర్క్ ఎవరికి అనిపిస్తుంది మరి? అవునా? జిమ్ములు ఎన్ని అవర్స్ పని చేస్తారు వాళ్ళు? ఎంత కష్టపడితే వస్తుందో లేవు, అట్లాగే ఉంటుందా? సచిన్ టెండూల్కర్ ప్లేడ్ ఫర్ 24 years ఫర్ దిస్ కంట్రీ. అంటే ఓవర్ నైట్లో పే చేస్తాడు అట్లాగా. ఎంత సాక్రిఫైస్ ఉండాలండి? మీరు కూడా అంతే. మీరు సక్సెస్ కావాలంటే కొంత సాక్రిఫైస్ చేయాలి. మీకు ఇది ఎప్పుడు అంటూ ఉంటాను ఒక స్టేట్మెంట్ మీకు. ఇఫ్ ఐ వాంట్ టు సీ ఎ బ్యూటిఫుల్ రెయిన్బో, little rain is necessary. One hand sunshine, other hand rain. Then I can see the rainbow. If I want to see a success, one had to sweat. నువ్వు కష్టపడకుండా నీకు సక్సెస్ రాదు. రిమెంబర్, ప్రొఫెషనల్ ఎగ్జామినేషన్లో అసలు రాదండి. యూ మే కర్స్ మీ ఇన్ దిస్ ఆస్పెక్ట్, బట్ దిస్ ఇస్ ఫ్యాక్ట్. షుడ్ అప్రిషియేట్, షుడ్ నో దట్. వై వుడ్ టెల్ ఆల్ దీస్ థింగ్స్ మీన్స్ వెన్ యూ నో వాట్ ఈస్ గోయింగ్ టు హ్యాపెన్, దెన్ యూ విల్ బి అలర్ట్. దాని గురించి మీకు చెప్తాం, ఏ చెప్పినా కూడా మేము. But again, that is you. 30 days time. Prepare well. I give my number, of course, already there. Whenever preparing, just call me back if you have any doubt. (98480-17462). This is useful. Whenever a silly doubt is there also you can respond. Call me back. If I am there in the class, I won't respond. You know pretty well, I won't attend. Otherwise, I will call back again. Better is in a WhatsApp, you can take one pic and you can share. Doubt also, that particular para, sentence were not clear, take one pic and share. I can help you out, no problem. Until examination, we are there for you. All the best guys, do well. It's your time, your chance. I played my best. Now onwards we have to play your best. My job is simple, just give